The federal government invoked the Emergencies Act, an extreme law that has never been used, and it announced 2 emergency orders that will have sweeping consequences on individuals, orders that it passed outside of ordinary democratic processes. The Canadian Civil Liberties Association has spoken out loudly against this declaration, and today we have our own announcement. We are taking the Government of Canada to court. Our society needs peaceful assembly, a critical democratic tool. And even though not every person may agree with the content of every movement, many protests are disruptive. It is possible for a gathering to be both disruptive and peaceful and non-violent. Disruptive protest, while often unlawful, like shutting down pipelines or camping out in a public space, can be the most effective way of raising awareness. And at protests, many different kinds of people might end up in the same space, joined by a common cause. The fact that some of the protesters may break laws, act aggressively or oppressively, does not necessarily mean that other protesters share their extremist views or conduct. We also recognize that the recent protests are having a considerable and difficult impact on the lives of those who live and work in their vicinity. We recognize that people in Ottawa have been profoundly and negatively affected. But again, we are here today because of the government's response to these protests and blockades. I'd like to now turn it over to my colleague, Abby Deschman, who is the Director of the Criminal Justice Program.
The Canadian Civil Liberties Association has retained counsel to launch a judicial review challenging the government's invocation of the Federal Emergencies Act. The Act gives the executive branch of the government extraordinary powers, and the legal threshold to use these extraordinary powers is intentionally high. Ensuring this threshold is met is a critical protection for the democratic process, the rule of law, and the civil liberties of individuals that may be impacted by these emergency orders. In our view, the threshold set out in the Emergencies Act, the legal requirements put in place to safeguard our democratic processes have not been met. We do not want to minimize the impacts that the protests are having on people across the country. But while some of the blockades have been immensely disruptive, it is unclear that the ongoing protests endanger the lives, health, or safety of Canadians so seriously that they constitute a national emergency. It is also far from clear that our existing laws and police powers are ineffective in confronting this challenge. Police deal with extremely complex, difficult law enforcement situations every day. Local police across this country have cleared several highly disruptive border blockades and are successfully managing numerous other protests in communities across the country, all without emergency powers. We believe that the federal government's invocation of these emergency powers is unlawful and unconstitutional. The Prime Minister has repeatedly said that the Charter of Rights and Freedoms continues to apply. We agree. And we believe that these measures are clearly unconstitutional. We will be asking the courts to step in to defend the rule of law and the constitutional rights of all people across the country.